All right, very good. So I'm beginning the recording and I'm turning it over to the judges.
Great. Good morning, everybody. Nice to see you able to be in each other's company there. That's great. My name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been judging this program for about 20 years, so it's the highlight of my year. Very glad to see you all there. And to my, I would say to my left or my right if we were in a normal hearing, but actually to my left at the moment, Richard.
Hello there. My name is Richard Leiter. I'm professor and director of the Law Library at the University of Nebraska College of Law, coming to you live from Lincoln, Nebraska. I've been judging state of Nebraska competitions now for about 15 years, and this is my first time judging the nationals. So I'm very happy to be here.
All right, good morning. My name is Kurt Mabus. I'm a Lieutenant Colonel, United States Air Force Judge Advocate General's Corps, practicing attorney for about 12 years now. Currently in Colorado Springs, Colorado, teaching law at the Air Force Academy, and an alum of the program as well.
Great. Can you introduce yourselves to us, please?
Good morning, and so nice to meet you guys today. My name is Mary Langosh, and I'm a senior at East Kentwood High School.
Good morning, my name is Safa Kareem, and I'm also a senior here at East Kentwood High School.
Good morning, my name is Liza Jyer. I'm also a senior at East Kentwood High School, and I'd like to introduce you to our coach, Mr. Justin Robbins.
Welcome. So I'll read the question for you now. Quote, a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
We agree with Jefferson that a Bill of Rights is necessary against any form of government. From Hammurabi's Code to the 12 Tables, Western civilization emphasized a system of legalism where rights and remedies at law are prescribed. Concurrently, classical Stoics and later St. Augustine promoted the concept that certain rights are immediately apparent through natural prudence and that any reasonable person would immediately recognize.
At Runnymede with the Magna Carta and later the Glorious Revolution of 1688 with the English Bill of Rights, a tradition of subjects granting power to a sovereign with limits began. This heavily influenced the natural rights philosophy of Locke, where individuals had rights in a state of nature. When entering a social contract, some power is granted to the government, while others are retained, necessitating their enumeration.
At independence, the founders were influenced by Montesquieu, who wrote that the only feasible configuration of a large-scale republicanism was a confederation of smaller republics. Under the Articles of Confederation, state governments and their citizens entered a social contract, and therefore would need to be bound by separate bills of rights.
This reflects Rousseau's theory in which each community collectively determines its rights. By having a state bill of rights, each state reflects its own unique values and traditions. The Articles of Confederation, however, proved too weak, and the national government was created via our Constitution. As anti-federalists like Jefferson would argue, this created a new contract, one which would be limited by a federal Bill of Rights.
Originally, through the 9th, 10th, and contemporary conception of legalism, each Bill of Rights only applied to its respecting governing entity. This was reinforced in 1833 with Barron v. Baltimore, where the Supreme Court ruled that the Federal Takings Clause could not be used to strong-arm local governing entities lacking federal jurisdiction.
Following the Civil War, however, this compartmentalization changed with the 13th, 14th, and 15th Amendments. The drafters' concerns highlighted the disadvantages of state Bill of Rights because they can't always be trusted to protect universal rights. Therefore, the Due Process Clause of the 14th Amendment is applicable to the states, mandating that a state shall not deprive any person of life, liberty, or property.
Since the 14th did not explicitly reference the Federal Bill of Rights, a process of selective incorporation began. This allowed the Supreme Court to extend the Federal Bill of Rights onto the states, beginning with the freedom of speech in 1925's Gitlow v. New York, and most recently with the requirement of a unanimous decision for juries in Ramos v. Louisiana.
Through judicial review, we've inherited a second Bill of Rights. Applying substantive due process, the Supreme Court recognizes additional fundamental rights by considering whether a right to life, liberty, or property is involved in a case, whether it's historically or universally recognized, and whether its deprivation would violate our conceptions of justice.
The application of substantive due process in Griswold v. Connecticut has established the right to privacy, while Roe v. Wade found the right to reproductive decisions. Loving v. Virginia emphasized the right to marry, and Pierce v. Society of Sisters established the right of parenting decisions.
Traditionally, the concept of rights focuses on negative rights, or the freedom from government interference, a right that would be enjoyed in a state of nature and withheld in a social contract. But as modern civil societies impact more aspects of our lives, a conception of positive rights evolved to limit the barriers towards individual agency through government action.
Positive rights are often conflated to justify massive distributions of wealth, but this is not the case. For example, the right to an attorney is necessary only because an individual's life, liberty, or liberty interest, only because our legal institutions are so complex. Providing a marriage license in Obergefell is only necessary because society has created a framework of rights and benefits around the status of being married.
In summary, a cornerstone of popular sovereignty and rule of law is the empowerment of individuals, the ability to point to a right and keep the government accountable. At that point alone, Jefferson's absolutely correct.
Thank you for your time. We are eager to answer any questions.
We're eager to ask them, and Canada will unmute to do that.
Well
Great. Well, what do you think was left out of the Bill of Rights?
As we've seen through the amendment process, that was protected with the Fifth Amendment, or Fifth Section, Fifth Article, goodness me, of the Constitution. When the Bill of Rights was established, there was kind of this society, the framers had the idea that as society changes, the rights we deem fit needed to be protected by the federal government would also change.
Additionally, some of the things that we felt weren't explicitly stated in the Bill of Rights, for example, like the right to privacy, that has been addressed now through the Supreme Court with judicial review and applying substantive due process. So those things are relatively addressed now that we have the 14th Amendment. So I don't believe there's anything else that would have to have an amendment explicitly written at this moment in time.
Are there issues, though, that you think should have been addressed?
Do you mean initially or currently?
In the Bill of Rights? Were there things that should have been addressed that weren't?
Ideally, we would have addressed things like slavery, which was later addressed in the 13th Amendment, as the Bill of Rights was trying to even the playing field out for every individual, in essence, to their protections from the federal government, along with suffrage rights for women as well, later in the 19th.
With that being said, we do not believe that there should have been any altercation to how our amendments did come to be. However, we see now that we are able to infer and enumerate some of our rights that are enlisted within our amendments to better protect us as citizens now through our upgraded and civil, society.
But
So you're thinking the courts have taken care of that?
Essentially now, yes. It just came to mind originally, I believe the 10th Amendment was there was supposed to be an amendment, otherwise it was the 10th Amendment that was supposed to actually make the Federal Bill of Rights also apply to the states immediately. But that version of the amendment was not passed and drafted into the Federal Bill of Rights.
So I can challenge, since you all agree at the very beginning, you all agree with Jefferson's quote, I can challenge you all equally. And you immediately went to St. Augustine that said there are certain rights that are just immediately apparent. So why do we need a Bill of Rights? Isn't all of you the problem with having a Bill of Rights? We just stopped certain things and gave everything else to the individual. Why do we need a Bill of Rights?
This is something that was debated even as the Constitution was still being drafted, especially with the anti-federalists. Because the federal government is prohibited in the actual Constitution itself to not prohibit our rights to habeas corpus or ex post facto rebels of attainder in Article 1, Section 9, it is in a way implied that the federal government would perhaps try to prohibit those. And if those can be, if there's a reason for them to take those away, why wouldn't they try to take away our other rights? That's something that would need to be written down so that we know we do have protection from that.
With that being said, for example, Article 1, Section 9 and Article 6 in the Constitution, which gives us the religious test to office by the president, all of which are totally feasible and totally right for us to already have. However, having the Bill of Rights just emphasizes and enforces that we do have specific rights listed to us, and those rights will be protected even if the federal government was to seem as if it was going to interfere in a way.
As my colleagues have said, the Bill of Rights is intended to protect our individual fundamental rights from the government. This debate can also be seen by Rousseau, where he says in social contract theory, as one participates in society, they give up all of their personal fundamental rights for the better of society, for society to function, which is later checked by Locke's idea of natural rights and his idea that the government should serve to protect those natural rights without the individual having to give them all up.
Okay, so since you raised this issue, under what circumstances can a citizen lose his rights that are protected by the Bill of Rights? And I guess as a corollary, how could they get them back?
One way that can be seen for citizens to lose their rights is if they are convicted of a felony charge. Unfortunately, that results in, for example, the loss of your right to vote in state elections, and sometimes. And ultimately, unfortunately, that issue must be resolved by the states. Otherwise, a federal legislature through the supremacy clause would also allow that to be enumerated throughout all the states.
With that being said, as previously stated, we do have this idea of a social contract. So we have to address times where we have to take back some of our rights in order to understand the common good and the common greater ideal that our state must provide in order for the state to then be able to enter a social contract with the federal government in order to have our rights not infringed upon and protected.
There are limits to our rights, however, and the process for taking them away would be due process through our judicial system, and that is stated in the Fifth Amendment and the 14th Amendment. We need to be given due process for that to reasonably be taken away. It can't just be taken away because someone doesn't like our free speech or doesn't like our religion, etc. Otherwise, beyond that, there have been other court cases creating specific limits, such as if there is clear and present danger as determined in Schenck v. U.S., then our free speech can be limited.
Canada, you muted again.
Is there any difference then between rights that have been added through the amendment process and those established by a court decision?
In some ways, yes. As, for example, using the right to privacy as established by the courts in Griswold v. Connecticut, it's not verbatim written in the Bill of Rights, for example, but it uses amendments such as the 9th Amendment to ensure that this societal expectation of privacy is established throughout the country.
Those rights that were recognized by the Supreme Court are more abstract, and those connect to our natural rights, because when when Jefferson had first talked about natural rights, like taking from Locke in the Declaration of Independence, he said, among these are life, liberty, and the pursuit of happiness, which implies that there are more beyond that. So the ones that the court is recognizing are ones that we should already have in a state of nature, like privacy. That's something we would expect in a state of nature. That's not something that is newly conceptualized. Meanwhile, an amendment is something that directly applies to the government, that is today's society, that we have to limit or give with a positive right.
With that being said, we can see that similarity and difference within other countries, such as like the areas of South Africa. For example, we do not need to address every single amendment and every single right in order for it to be there. However, there are areas like South Africa who do enlist many amendments and many rights for them to have to uphold and enforce in order for it to be made.
Great. I was just letting you finish your sentence. Thank you so much. That was a great job.
Yeah, good job.
Great job. Good. Richard, do you want to start?
Sure, be happy to. I want to congratulate you on a wonderful presentation. I thought that each one of your roles in the presentation was very well balanced, one to another. You did a great job of handling the questions. You know, we're dealing with a unit and a question in this whole We the People program, where we're talking about ideas and concepts that don't have an easy answer. And it was gratifying to me as a professor and somebody with interest in constitutional law to hear you guys struggle with the questions. And you did a really fine job. You should be very proud of yourselves. Thank you.
Yeah, I'll echo that with just the depth of presentation that you provided. And what I liked about it was during the Q&As, you went back into what you already talked about, brought it in and kind of explained it a little bit more. Here's my challenge / keep doing it. Sometimes I see the wheels turning and you tell me an answer, but I don't know why you're citing that authority. So give me that link, because I might miss that link. I might be thinking of something else. You did a pretty good job of it, but I'm going to challenge you to just remember, we're not thinking what you're thinking all the time. You might be smarter than us. So you got to get me there, So, but it was a wonderful job. Really enjoyed the conversation. Thank you.
I'd say might be smarter than we are. I'd say pretty clear to me. That was really a lovely, lovely job. Thank you. And I hope that you enjoyed doing it as much as we enjoyed listening to you, because you certainly seemed as if you told us a whole lot of information, but know a whole lot more than you were able to share in 8 minutes. And I hope this has been a wonderful experience for you. I was really impressed with your references to all kinds of things that just sort of tied it all together, not just the natural rights background, but the Rousseau reference. And it just was, everything that you brought in was well connected to the point you were trying to make. It was good support. You had very good support for what you were trying to say. And I hope that you might end up being nurses and dentists, but you might also be interested in political science and go forward and not only do a great job as citizens and people to inform your neighbors and family and friends about why they should vote the way they do. And I'm sure you'll be voting every chance you get. But I really hope that you might have an opportunity to represent the rest of us down the road, because what we really need is people in government who know as much about government as you do. I would say you certainly know more than anybody in my law school class would have understood about this. So you're already 5-10 years ahead of yourself. So I just hope that this is inspiring you to be the people that we need in government, that I can sit in my rocking chair in my nursing home and not worry. I'll be able to sleep well at night knowing you're there. Thank you so much. It was a lovely job.
Thank you.
All right, very good. So the judges are going to be heading back to their breakout room, and thank you very much. And good luck on the rest of your